Good afternoon again. My name is Todd Gaziano. I'm Executive Director of Pacific Legal Foundation's DC Center. And on behalf of Pacific Legal Foundation and National Review Institute, I want to welcome everyone here to our 4th annual Supreme Court preview. As I mentioned earlier, I also want to welcome the viewers who are watching this on tape delay. And to them, I say, I hope the future is as cool as we were told. As we also do every year, the past 3 years, we want to especially thank Jones Day for the use of this wonderful room and their very professional and courteous staff. Before I introduce our moderator, who is backed by popular demand from National Review, I will provide a very brief Pacific Legal Foundation Supreme Court update. Unfortunately, last spring, we lost our first case in 10 appearances before the Supreme Court. Naturally, we should have won, but we will continue to advance liberty even if we only win 9 out of 10 of our next appearances before the Supreme Court. In the current term, we are one of several parties in a case that will be argued on October 11th involving the proper jurisdiction for challenges like the one that is the immediate challenge under the Clean Water Act for the Water of the United States rule. We also have 8 pending cert petitions before the court right now, so we may be back. If there's a lull in the audience questions, I might be forced to ask our distinguished panelists about 1 or 2 that I think is particularly interesting. Well, anyway, the program today is that our panelists will talk about the cases first that are already on the docket, including at least 3 that were granted just yesterday. They then may address each other's remarks and any potential petitions that are on the horizon. And then I'll return to this podium to recognize you all in the audience for your questions. Our moderator today, as I said, is Ramesh Ponnuru from National Review. He is well known to this audience, and that's good because he and I agreed to keep the introduction short. So I will just say that he is senior editor at National Review. He's a columnist with Bloomberg View, and he is a fellow at the American Enterprise Institute. He also continues to earn great respect for his writings on the intersection of judicial decisions, public policy, and culture. With that, Ramesh, please proceed.
You know, I should note that I'm also a fellow at the National Review Institute because one can never have too many titles. Thank you so much for joining us today. And I join Todd in thanking Jones Day for again hosting this terrific event. And as he suggested, I'm going to keep my own remarks brief. I'm just here to introduce our panelists. I can't really do them justice because if I were to talk about all of their laurels, we would be here all day. So just the truncated version, I'm afraid. I'll start with Ginger Anders, who is with the appellate lawyers at Munger, Tolles, and Olson. She previously served as an assistant to the U.S. Solicitor General and a deputy assistant attorney general in the Office of Legal Counsel. She's argued 18 cases before the Supreme Court, and during her nearly 8-year tenure in the Solicitor General's office, she argued a number of important intellectual property law cases, particularly patent cases, as well as cases involving the Foreign Sovereign Immunities Act, transnational law, administrative law, and constitutional law. And we owe a special thank you to Ginger for being able to fill in at the last minute for her partner, Don Verrilli. Thank you very much for joining us. Michael Carvin is a partner in Jones Day's Issues and Appeals practice. He previously served as Principal Deputy Assistant Attorney General in 2 U.S. Department of Justice divisions. He is currently one of the leading appellate and trial lawyers challenging state and federal regulations on constitutional and statutory grounds. He and Paul Clement were the principal arguers for the position that Obamacare was unconstitutional in the first major challenge to the Supreme Court in 2012. Of 7 previous cases he's argued before the Supreme Court, he has lost only 1. You may also recall that Mike argued before the Florida Supreme Court on behalf of George W. Bush during the recount of 2000. Some of our younger audience members, you can ask somebody else to explain the background for you. John Elwood is a partner in Vincent & Elkins Appellate Practice Group and the Realist Watch columnist for SCOTUSblog.com. Like both Ginger and Mike, John served as Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel. And like Ginger, he also worked as an assistant to the Solicitor General. John has argued 9 cases before the Supreme Court, including some interesting criminal cases, a First Amendment case, and one that presented both issues. He described that last case involving a criminal defendant with a First Amendment defense for his allegedly threatening rap lyrics 4 years ago at our first PLF NRI Supreme Court preview event, and he eventually won that case. So with that, I'm going to turn it over to Ginger to start our discussion of the meat of today's panel.
Great. Well, thank you very much. I'm very happy to be here. So I'm going to start a little bit slow this morning because the first case I'm going to talk about is actually no longer on the docket. This is the travel ban case. So I thought I'd give just a very, very brief and oversimplified summary of how we got here. So the travel ban that was issued in the spring, in its 2 initial phases, applied to 3 categories of people: immigrants, non-immigrants, and refugees from certain countries. It was by its terms temporary in order to allow the executive branch to review the security protections that it employs when those people try to come into the country. In the spring, the Ninth and the Fourth Circuits overturned the ban, but the executive was allowed to continue with its review while this is percolating up through the courts. So the government sought Supreme Court review. And in June, the court issued an order that permitted the government to enforce the ban against people essentially who had no prior connections to the country. But probably the most interesting thing was what it didn't do. It didn't set the case for immediate review. This was June, it was the end of the term, and the court said, we'll hear the case in August, so we'll have briefing over the summer. And it expressly stated that the executive could continue the review process that it was undertaking, and that those 2 reviews, the review of refugees and the review of visas, would both conclude naturally by the terms of the order around the time the court was slated to hear the case. So the court itself asked the question whether the case would be moot. So I think at the time, this sort of gave the impression that maybe the court was not overly eager to hear the case. One can imagine that this would be a pretty difficult case for someone like Justice Kennedy, for instance. There are really 2 sort of opposing instincts here. The first is that there's a really well-established, constitutionally based doctrine of deference to the executive branch when it takes actions in the immigration area, especially when those actions involve national security, when they involve foreign relations concerns. So you have that on the one hand. On the other hand, you have the way that the first travel ban was rolled out, the sense that you seem to see in the lower courts that maybe there hadn't been a lot of executive branch process, or certainly not the normal processes that would have happened before the travel ban was enacted. The chaos that it caused in the airports, the tweets surrounding it, all of that may have given some justices like Justice Kennedy, some pause at least. Did they want to be upholding that? And so they may have felt that they were caught between these 2 opposing impulses. So summer went by, the review happened, and on September 24th, the executive issued a new travel order. This one was designed to address some of the legal flaws that the courts had found in the first 2. And so it went into a fair amount of detail about the review that the United States had undertaken to determine whether it could establish adequate protections to allow people from basically all the countries of the world to come into the United States. And so the new ban determines that with certain countries, I think there are 9 of them, it's actually not possible to have enough assurances that the people who come in are who they say they are. And those countries are no longer all predominantly Muslim countries. So you have more targeted restrictions, and they apply without reference specifically to religion. So the Supreme Court, I think, canceled the argument and ordered further briefing on mootness. That briefing is due next week. But I think the fact that the court canceled the argument so quickly, may suggest what seemed to be the case back in June, that it was not overly eager to hear this case. And so, they may prefer to let this play out in the lower courts again. So, the question is, what happens now? the new travel ban does not apply to refugees, so that part of the order is probably not technically moot. But the review that's going on for refugees ends in October, and so presumably the executive will issue a new order with respect to refugees as well, at which point that part of the original travel ban will become moot, probably, unless something unexpected happens. So with that being said, presumably what happens now is that the people have to challenge the new orders, go back to district court, presumably, and do that. And it seems like at this point it's just a much heavier lift for the challengers. If the concern before was that it didn't seem like the executive had really undertaken any of the reviews it usually would. Now the executive has gone to great lengths to tell us what it's done, and the order is no longer facially based on something that could be construed as religious discrimination. So it seems like now it may be much harder to discard the doctrines of deference to the executive that have generally applied in the immigration context. But I will say the one wild card in all this may be whether the president says more about the case as it's going forward. Because one thing that was happening, as the original travel ban case went forward, and I imagine was quite frustrating to the government attorneys, was that you had tweets, you had public statements that were somewhat at odds with the government's legal strategy in the case. And so when you have that happening, it's possible for those sorts of statements to undercut the government's argument, which is going to be that, look, now we've undertaken the review that we were supposed to undertake, and there is no way to claim at this point that what we've done is tainted by the initial travel ban. So I think that'll be interesting to see as it goes forward in the lower courts. So then, for something completely different, this next case that I'm going to talk about is a patent case. This is called Oil States versus Green Energy. And so this case involves whether the PTO's system for reevaluating whether it should have issued existing patents is constitutional or whether it violates Article 3. So this arises out of an increasing sense in the 2000s that there are a lot of bad patents out there. There are non-practicing entities that make a business model out of suing or threatening to sue based on patents that they don't actually use, and that was jamming up the courts and also creating a lot of problems where people would settle without even going into litigation. So in 2011, Congress acted in the America Invents Act, and it created a procedure called inter partes review. And it's basically just a modification of something that already existed in the PTO, but it allows third-party challengers, such as accused infringers, to go to the PTO and say, particular patent is invalid. And the PTO then reevaluates that patent after hearing from the challenger, hearing from the patentee, and it reaches a decision, and it can cancel the patent at the conclusion of that review. So the challenge comes from a patent holder whose patent was invalidated that way. And basically the argument is that historically patent validity has always been decided by courts because it usually happens in the context of an infringement suit. So the patent holder sues for infringement. The defense is that the patent is invalid, and so that goes to the jury along with the infringement questions. So if historically that was the case, then can Congress now take that question and give it primarily to an executive agency consistently with Article 3? So, the first thing to note about this case is that it has potentially sweeping consequences. I think the industry, at least, thinks that, particularly the tech industry, companies that are using IPR a lot think that it's been working pretty well, and that what it's done is that it has gotten rid of the most vulnerable patents first, the ones that really seem to be stopping up, the economy without protecting a lot of innovation. And so, you could have all of that going down if the court rules for the challenger here, and all of this could go back to litigation. But you'd also have a question about what to do with the thousands of patents that the IPR procedures have already invalidated. Do those come back to life? What happens if people have been infringing them? So there are a lot of pretty difficult questions that could arise from a decision in favor of the challenger here. And in terms of what might happen, I think Article 3 questions have tended to break down on left-right lines recently. So the left-leaning justices tend to be a little bit more pragmatic, a little bit more receptive to cases particular types of claims being adjudicated by agencies. The right-leaning justices have tended to be a little bit more formalistic. Is this a type of case that would have been decided by a court historically? They ask those sorts of questions. So you could see that kind of breakdown here. But there are a couple of things that may weigh against that that make this case, I think, particularly interesting. The first is that all of the justices, to some extent, have been concerned about non-practicing entities and bad patents. That's in part why the court has gotten back into the business of reviewing the Federal Circuit so often. They've been trying to cut down on some of these very broad patents, very abstract patents. They've started talking about these problems in opinions. There's a Justice Kennedy opinion from a few years ago that talks about non-practicing entities and how harmful they are. So the court is going to be sympathetic to the fact that Congress was trying to address this problem when it created IPRs. And then the other thing I think that's interesting here is that Justice Thomas has actually made a lot of statements in a couple of concurring opinion and dissenting opinions where he has suggested that he thinks that patents are private rights. And so, that they're public rights, which means that they could be adjudicated by a non-Article III court. And so it may be that Justice Thomas is actually much more sympathetic to the IPR proceeding than we might otherwise have thought. And so if that's the case, then you could see some sort of, the four left-leaning justices plus Justice Thomas lineup. So that'll be interesting to watch. And the last case I'll talk about just very briefly is a case called Collins versus Virginia. And this case is about the automobile exception to the Fourth Amendment, to the warrant requirement. And the question here is whether that exception applies to a motorcycle that's parked in the curtilage of your house. So the automobile exception says that you can't, that when an officer stops a vehicle and obtains probable cause to think that there's contraband in the car, he doesn't have to get a warrant before he does the search. And the rationale is that when you do a traffic stop, you're stopped on the road, it's not practical to get a warrant, and you have less expectation of privacy if you're just driving on the road. And so it seems like those principles really may not apply here, where a car is actually, or the motorcycle in this case, was actually parked by the house. And so I think this could be a case where you see the justices combining solicitude for Fourth Amendment rights on the part of left-leaning justices, concern about private property and trespass for the right-leaning justices, and then the fact that it doesn't seem like the police would be harmed if they have to go get a warrant before they search a parked car. So I think all those things may combine here to see a verdict in favor of the defendant.
Thank you for that very brisk review of those cases. Hopefully you will equal or exceed that briskness.
I can do neither, but I'll give it my best. My cases, I think, all come under the heading of deja vu all over again, which will be sort of clear when I walk through them. The first case I'm going to discuss is the Wisconsin gerrymandering case called Gill. And basically, this is the search for the Holy Grail, the unicorn. Can we figure out a manageable judicial standard for figuring out when there's too much politics involved in redistricting in line drawing? The court's been at this for 30-odd years, and they begin with the premise, which has been embodied in a lot of Supreme Court opinions, that obviously we're not surprised that there's politics when politicians draw lines. We're not surprised that there's gambling in Casablanca. We're not surprised that bankers pay attention to money, politicians will pay attention to politics. So that's a given that it's going to be part of the process. So then the question is, well, when does it go too far? Specifically, when does it affect the voting rights of the disfavored parties, which in this case is Democrats, so I'll use them. When is their right to vote really been hurt? And that's a tricky issue, right? Because Democrats get to vote just in the same sized population districts as Republicans. Their access to the ballot is completely unimpeded. So what you're really talking about is not any ability to vote. You're talking about group voting power. And you're saying that on a statewide basis, we have a group vote of, let's say, 50%, and we're only getting 40% of the seats. So it's the difference between the number of votes we have and the number of seats we have. So we have disproportionate representation. The problem with that theory, although it does trace what you would think of as vote dilution, for example, in the race context, if blacks were 30% of a district and we're only getting 20% of the seats, is that the first time the court took this up in the mid-'80s was in Davis versus Vandermeer, and they said, look, there's no right to proportional representation, so you've got to come up with some different theory for figuring out why you've been hurt. And the Democrats gamely tried in a 2005 case called Vieth versus Pennsylvania, and they said, listen, we're not arguing for proportional representation unless you're a majority. If you're a majority, you do have to have a majority of the votes. You do have to have a majority of the seats. So if you have 51% of the votes, you can't get 40% of the seats. And that was rejected out of hand by 5 justices on the Supreme Court who said that's just a variation on proportional representation. So that theory doesn't work as well. At that point, 4 of the justices, led by Justice Scalia, said, look, this is hopeless. We're never going to come up with any kind of judicially manageable standard. This is non-justiciable. Let's go away. Justice Kennedy, the eternal optimist, was, well, you know, there's a lot of smart lawyers out there. I can't think of a theory, and nobody's ever given me a theory, but, you know, maybe somebody will come up with something. Let's keep litigating this for the next 10, 20 years. So 12 years later, we're now back, and the Democrats in Wisconsin have come up with a purport to be a new, easily administrable standard for distinguishing too much politics from okay politics. Few problems with this. The subtle listener may figure out that I've got some definite views on all this, so factor that into what I'm about to say. But look, the truth is they've given Justice Kennedy absolutely nothing, because all they've done is come up with the same retreaded theories. Their first problem is, in an effort to prove that there's an administrable standard, they've come up with 3 different standards at 3 different stages of the litigation. In district court, they said, well, the real standard is this so-called efficiency test. In their briefing on whether or not they should take the case, they said the real standard is something we're going to call partisan bias. And now in the merits briefing, they're saying it's a 3-part multi-factor balancing test. I'll just briefly walk through why none of those really work. They're all variations on the proportional representation thing. The efficiency gap, and I know I'm really getting into the weeds here, but it really makes no sense, because the efficiency gap says, how many votes have you wasted? They count wasted votes to mean if you vote for a candidate and he loses, those votes are wasted. And if you vote more than 50%, then those are wasted. So the farther you are over a 50, that makes no sense. Just think about that for a second. The Democrats lose in a district where they get 49.9% of the vote. Republicans get 50.1%. That's just the kind of district you would want. Under this efficiency gap, that means you've wasted 49.9% of the votes. If you pack the Democrats into a packed district where they get 75% of the vote, which is the traditional hallmark of redistricting, then there's only 25% wasted votes. So under this theory, you would prefer 75% packed districts versus perfectly competitive districts. Paul Smith, who's representing the petitioner, sort of recognized this after it was sold to the district court, has abandoned that theory. Plus which, of course, for all of these measures, you need to figure out, well, what makes it worse? I mean, what's the gap between the parties have to be judicially cognizable? For the efficiency gap, they came up with the number 7. Which was to me odd, because normally they come up with like 10 or, you know, something round. 7, I guess they got from craps. The reason they did it was because that's the number that they had come up with in this case. So coincidentally, that was the distinguishing factor between good and bad plans. Second argument they made was the so-called partisan bias argument, which I actually was the first one to introduce into federal courts. I can take proud ownership, because back in the day, remember, it was the Republicans who were suing the Democrats for gerrymandering, and I thought this was a great theory. If you were actually doing okay, you could still strike down the plan. So then all these political science professors said, yeah, this is a really good idea, because you need to get around the proportional representation problem. So here's what partisan bias says. It doesn't say, do your seats equal your votes? It says, do your votes equal the amount of seats that the other party would get at the same number? So they say, it would really be bad to say, if the Republicans get 50% of the vote and 60% of the seats, to condemn it on that basis, because that would be proportional representation. So you have to ask the second question, how many votes would the Democrats get at 50%? Of course, the answer is 40%, because the Republicans just got 60%. So they're saying, see, this is different than proportional representation. So you can go forward with this theory. And anyway, it gets very complicated. Justice Kennedy basically rejected this approach in this LULAC opinion, so that's going to be a non-starter. So finally, the final last refuge of any scoundrel is to propose a multi-factor balancing test, which is now what they've done in the Supreme Court. Well, was there a lot of purpose? Was the effect large? We won't give you a number. Was it durable? We won't tell you how you figure that out. And did they adhere to traditional districting principles? So if you're trying to bring consistency and a bright line to a standard, I don't think this multi-factor balancing test is going to do it. I don't know where Justice Kennedy is going to go on all this, but I can tell you they've given nothing that he's asked for. My cynical hope is that they're going to turn this down because they realize if they adopt anything like what the petitioners are proposing in the next redistricting cycle, you got to remember, redistricting cases are direct appeal to the Supreme Court. They will have at least 50 cases they're going to have to decide themselves under this three-part balancing test, which I'm hoping will be the death knell for this theory. The other deja vu all over again is the court yesterday took this Janus case out of Illinois, which asked the questions, can non-members of public union sectors be required to pay union dues? This is a replay of a decision that was up there 2 years ago in Friedrichs, where the general consensus was that the court was about to strike down these things on First Amendment grounds, but then Justice Kennedy passed away, so it was, excuse me, Justice Scalia passed away, I apologize. And we went from a 5-4 to a 4-4 decision. That case, I should add, was brilliantly argued because it was my case. But now we're back. I think the conventional view is that this is going to be struck down. The argument in favor of it is very weak. There's a basic principle, obviously, you can't be compelled to support speech with which you disagree, at least for matters of public concern. The speech that's at issue here, there's a decision out of the 1970s called Elwood that said, you know, that's entirely true, so you can never be required to pay a union for fees for lobbying state legislatures, because that would be political. But they drew a distinction and said, but if they're lobbying school boards in connection with a collective bargaining agreement, then you can be required to support that. A couple of decisions prior to Friedrichs, Knox and Harris made it clear that that distinction didn't make a lot of sense. And the major rationale has always been, gee, all these non-union members would be able to free ride on the good things that the unions are providing them if they didn't have to pay union dues. But the last argument indicated that Justice Kennedy was very skeptical of that argument because he said, look, first of all, they're not free riders, they're compelled riders. You can have a members-only union where you only represent members, but you've reached out to conscript these non-union members and bind them to the same collective bargaining agreement that you're negotiating. So it's one thing to say somebody can't get on a bus and free ride. It's quite another to make them ride on the bus and then demand payment. Plus, which of course it's a bit counterintuitive to think that people who have divorce themselves from the union think that what the union is bargaining for in the collective bargaining agreement is somehow benefiting them. So Justice Gorsuch has never weighed in on this. If you look at his First Amendment jurisprudence in the lower courts, it looks like he'll accept this basic principle. So it looks like this decision will go down. There'll be one remaining point on all this, whether or not you can require the non-union members to opt out of paying these fees or whether or not he has to affirmatively opt in. That question is not presented in this case, but it is presented in some lower court cases that may reach the court shortly. I think I've basically run out of time, so I'll leave any further discussion until the question session. Thanks.
Terrific. John?
My first case is Masterpiece Cake Shop versus Colorado Civil Rights Commission, which is a blockbuster First Amendment case. You are familiar to the case from 1,000 bad puns that have been told around the Twitter sphere recently. It involves a Christian baker whose lawyers bill him as a cake artist, which sounds regrettably like Subway sandwich artist, but it's a fair description because he really does put genuine artistry into his cakes. He refused to make a same-sex couple's custom wedding cake, and they sued him, and the Colorado Civil Rights Commission ordered him to make same-sex couples anything they had make for a heterosexual couple, and the Colorado Court of Appeals affirmed. He raises free exercise and free speech challenges to that. One thing I wanted to note at the outset is this is the most relisted case the Supreme Court has ever granted. And as you may know, when the court is looking hard at a case, they'll consider it at one conference, and then they'll consider it at another conference, and then that's called a relist. In this case, they did that 14 times, which is higher than the previous record holder, which was 8. And some of that can be explained away by the fact that they were trying to save this case or wait long enough for Justice Gorsuch to weigh in. But they relisted it, I think, 9 times after he joined the court, which to me is a sign that they didn't have the 4 votes to grant. You would have thought with, at least 4 conservatives and Justice Kennedy, there would have been an earlier grant. But, the way I read this is that Justice Gorsuch added to Thomas and Alito to be a 3rd vote to grant, and through a course of writing dissents, peeled off a necessary 4th vote. But it does suggest some reservation among the more conservative justices about the case. It's also interesting because the court didn't take a case involving a very similar issue a couple terms back, Elaine Photography, involving a wedding photographer, which they relisted twice and then denied. And in that case, there was actual, it would compel somebody to actually participate in the ceremony, whereas this, he's just making a cake that will be used at the ceremony. And query what the difference is. And as far as I can tell, I think the thing that probably matters more is this is more like conventional speech in that, he has written cakes that say God bless on them. Admittedly, that was a christening cake, but go with me on this. And he's also made a cake that showed a heterosexual couple embracing in front of a cross, and that was an actual wedding cake. I would not put it on a wedding cake myself, but different strokes for different folks. But I think that that's, an indication that there's more obvious speech, including real live speech in the form of words, that might be involved here. And secondly, I think one other thing that may have gotten the court's attention is at least the argument that there is favored and disfavored speech, because there are instances where people who did favor same-sex marriage, refusing commissions to make cakes that denigrated the idea of same-sex marriage, whereas people who oppose same-sex marriage can't limit themselves only to heterosexual cakes. And so they may have seen some sort of RAV versus St. Paul kind of, that the government was taking sides in the debate. And I know there's arguments on the other side, but I'm just saying what might have interested the court in this case. So as I say, they're both free exercise and free speech issues in this, but because of Employment Division versus Smith, the case that said basically laws of general applicability, you're more or less out of luck on free exercise claims. The only way you can win on free exercise is if it's a so-called hybrid claim that also involves free speech. So all of the action is going to be on the free speech side. Now, my grand unifying theory of Justice Kennedy is that if you lose on the merits on an issue, you at least get to complain about it. This you see in the kind of abortion context, because remember his very impassioned dissent in Hill versus Colorado, where he wrote, quote, "Foreclosed from using the machinery of government to ban abortions in early term, those who oppose it are remitted to debate the issue in its moral dimensions. In a cruel way, the court today, because it was an abortion protest case, turns its back on that balance." And so I think that this is going to make him kind of interested in the idea that people, if they, they may have lost Obergefell, people who oppose same-sex marriage, but they at least get to, speak out against it. This is a public accommodations law, and so the bad hypotheticals all involve, well, could he turn down, an interracial marriage cake or something like that? And Kennedy did salt away language in Obergefell about how, ordinarily like racial animus, there's no patience for that in the Supreme Court. But Obergefell is full of references about the kind of the decent and honorable beliefs that lead people to oppose same-sex marriage, and also said about how they get to continue with their teachings even after Obergefell. And I think Kennedy has a very broad view of what teachings are. That said, and I also think that the parade case from many years back as a Souter opinion involving the Boston, St. Patrick's Day parade, where the parade organizers were allowed to prevent gay and lesbian Irish from marching in that because it would change the speech of the assemblage. I think that that's going to be a strong precedent for the Baker in this case. I do think it's going to be tough for Kennedy, though. I mean, because you do worry about people exempting themselves from laws of general applicability and public accommodations laws. I think he'll have a tough time with it. And in case you haven't picked up from this, I think that his is the only vote that's really in play here. But we will see. I might be wrong about that. One other thing to keep an eye out for is there was a case a couple terms ago, Stormans, involving pharmacists who wanted to not dispense Plan B because of religious objections to it. They were forced to, supply it anyway. It got 3 votes, didn't get Kennedy's vote for a grant, and Justice Alito wrote that this case is an ominous sign. And so query whether there's more to be read into that. I just raise it because I don't know what the answer is, but it's worth thinking about. Second case is Carpenter. I better hurry up here. Most important Fourth Amendment case in years. When you wander around with your cell phones, the way that it knows how to charge you for roaming charges and things like that, and to locate you for 911 calls, is it records your position in relation to cell towers. Uncle Sam figured out this is a great way of putting people at crime scenes. And so they subpoena these cell phone historic records using the Stored Communications Act, which doesn't require probable cause like a warrant would. It requires more like the Terry standard, which is specific and articulable facts showing reasonable grounds that it's relevant to an investigation. And so the question here is, and it's a bunch of cases, court took a bunch of cases without a circuit split, whether you need probable cause or whether the Stored Communications standard is enough. This is, an important opportunity for the court to revisit so-called third-party doctrine, which holds that if records are held by a third party, you're exposing that information to third parties. You don't need probable cause for that, for telephone numbers you dial, for bank records and things like that. But there is some discomfort with applying that to cell phone records, Justice Sotomayor has already expressed that in her Jones concurrence a couple of years ago. Another big issue is that the justices are very uncomfortable with the idea of this kind of data over time. In the Jones case involving a GPS transponder connected to a car, it was 27 days, and it was very detailed information. Here, it's more approximate information. It's not exactly where you are, it's the neighborhood where you are, but over 127 days. And I think that the justices, that very well may give them heartburn. But an important thing here is the role of legislation, because in the Jones separate opinions, both Alito, who wrote for 4 justices, and Sotomayor, who wrote for herself, she was one of the majority also, both made a reference to Congress's role in line drawing, and query here whether it's enough that Congress did the Stored Communications Act when it was clear that that wasn't really designed for this kind of location information and maybe more for just subscriber information. My last case, but one thing I think is interesting about that is generally those kind of issues cut across kind of ideological lines, and you get weird combinations like Sotomayor joining the conservatives in Jones and Alito joining the liberals in Jones. Last case is one from granted yesterday, Dalmazzi, Cox, and Ortiz, which involves a question of, these guys are all enlisted, or they're all military people in the Air Force. And they challenged their convictions and the affirmance by the Court of Appeals for the Armed Forces and from the Court of Appeals for the Air Force, because one judge on that was also serving on the Court of Military Commission Review. And there's a law that goes back to just after the Civil War that says, unless otherwise authorized by law, a regular officer of the armed forces on active duty may not hold a civil office in the government of the United States that requires an appointment by the president with the advice and consent of the Senate. And so they say that because our judge was put on the Military Commissions Court, it invalidates the affirmance of our conviction by the Court of Appeals for the Air Force. The court took this yesterday. The government interposed 4 arguments why this was a ridiculous argument. So they have to run the table in order to win. The challengers have to run the table in order to win. 2 of them, this is a case that geeks will love and OLC alumni will love, because the first 2 issues both rely on the correctness of old OLC opinions for the challengers to win. One saying authorization has to be super specific, a John Harmon opinion, and it must be discounted because it was Jimmy Carter's OLC head, and he appears in his official portrait with his dog. I'm being facetious. But, and the second opinion, though, is Ted Olson opinion, and that says that civil office is very capacious, whereas the government says it's a military commission, that's military. So it'll be interesting to see what happens with this. If you're interested, why did they take this case when the government had such good arguments on the merits? It's this, I think, is the real reason, because this issue has also been raised by military commissions people. And what I think the Chief Justice is shrewdly doing is resolving this in a much lower temperature case involving people convicted of sex crimes with children and kiddie pornography and using ecstasy on Air Force bases, as opposed to with Khalid Sheikh Mohammed. So I think this is an installment payment in order to get rid of this case, but I think that the challengers have their work cut out for them.
Great. I'm going to ask now if any of the panelists would like to comment on some of the other cases that the other panelists have discussed.
Sure. So I think there are a couple other interesting things about Masterpiece Cake Shop. One is the historical context here. So in the 60s, when Congress was considering the Civil Rights Act, one thing that happened was that there were a lot of religious objections to integration. And so there was a lot of testimony. It was all taken it was very, very serious objections. These were taken seriously. These are people of good faith, but they were making these, arguments that, the Bible said certain things, and that meant that they shouldn't have to integrate. And so that history, I think, sort of informs some of what's going on here. The court, by the 80s, had roundly rejected our religious objections to civil rights laws. So that's the backdrop of this, whether same-sex protection should be treated differently, than those other rights. And so I think Justice Kennedy is one of the things he's going to have to consider is whether that protection for same-sex marriage that he just upheld, as John said, is something that is more susceptible to individual exemptions than protections against race and gender discrimination. And maybe the answer is that yes it is. But there will have to be some kind of rationale for that. And that sort of brings me to the next thing that's interesting, which is that the government filed a brief in Masterpiece Cake Shop, which I think was somewhat surprising because putting aside politically which side the government falls on here and what the administration thinks of all this, there is sort of a long-term institutional government interest at stake here, which is that the government enforces the civil rights laws and the federal government has federal public accommodations laws. And so here the government was essentially saying, we think that at least in some cases there is a First Amendment exemption to these public accommodations laws that we otherwise would be enforcing. And that is an unusual position for for the government under any administration to take. Usually they're all for broad enforcement in every situation, and they're very leery of recognizing constitutional rights that can be interposed against this kind of enforcement. So the government in its brief took a crack at distinguishing race here and basically said, well, race is different because we're very, very concerned about racial discrimination more so than we are about other types of discrimination. They didn't do it at any great length, so it's a little bit hard to know what they mean. Maybe that'll be fleshed out at oral argument. It's kind of interesting in the First Amendment context. We don't usually distinguish between types of speech or types of objections based on the subject matter of those objections. That's something the First Amendment doesn't have you do. And so it's unclear whether that doctrinally sort of fits in here. So that's something I think will be interesting to look at in Masterpiece, the government's side of the argument and how the court reacts to them.
A couple of quick comments on that. I think it's a fair presentation. I think there's an important distinction here, right? It's not as if the owner was excluding gay people from buying cakes, which would be classic discrimination based on sexual orientation. He didn't want to participate in a same-sex marriage. Even if a black owner of a cake shop couldn't exclude white people, obviously, presumably he would have much greater ability to say, I'm not going to bake a cake or cater a Ku Klux Klan meeting because it offends, because it's not exclusion on the basis of skin color, it's exclusion on the basis of something I disagree with, particularly, as John noted, with respect to Justice Kennedy's opinion. The people who sold Proposition 8 and all of these gay marriage things was, listen, we're trying to promote tolerance and diversity of viewpoints. All we're asking you is to accept something that really doesn't affect your life. If you don't believe in it, that's fine, but these people should have a right to do it. And that movement is pretty seriously morphed into the notion that we're not going to tolerate dissent on the question of whether same-sex marriage is a good or bad thing. We're going to extirpate from society anybody who disagrees with our view that same-sex marriage is equivalent to interracial marriage and the like. So equating people who have reservations about same-sex marriages with Southern bigots is probably something that may not resonate with Justice Kennedy.
So the only comments I had were first on Gill. I always thought that Justice Kennedy kind of liked, first I think he's kind of a never say never kind of guy. For starters, and it's hard for him to say that you could never come up with a particular argument. But I think also there is a certain element of it that he kind of liked the strategic ambiguity of his views and the sort of the interiorum effect, to borrow Irv Gorenstein's phrase, in this context, of letting people, giving the idea to people, don't go too far, or I might be able to find the one thing, the one type of gerrymander that goes too far. And it'll be interesting to see what happens. Obviously, his ability to exercise the interiorum effect is lessening as he is. I guess he turned 80 last year or whatever. Anyway, it'll be an interesting case to watch, and I think it's one of the most important cases in a term full of important cases. The second one is just I've always marveled over, this Janus case involving that Mike talked about, and I've always marveled over the fact that it's the third time, actually now the fourth time that this has been up here, and then the first 3 times they couldn't quite seal the deal. And I was always amazed by the fact that those first 2 times they didn't get there. It's both kind of, they've thrown enough cold water on this Abboud case, to fill Lake Erie, and they still haven't overruled the thing. And I always wonder if, even though it seems like the handwriting is on the wall, whether this is going to be kind of like Fisher 2, where everything looks like everything's going to go in favor of the challengers, but at the last moment, Justice Kennedy comes out with some what he thinks is a narrow opinion. So I just lobbed that out to cause you nightmares. And then the last thing I wanted to say is that when the travel ban stuff was percolating over the summer, I thought, I'm not going to get anything done if I pay attention to this case, because there's just so much going on every day. And I think that the court will say it's moot. But if it does moot it, I will feel vindicated that I saved all that time not paying attention to the case over the summer.
So, you know what? Before I turn it over to the audience question, just a real quick kind of lightning round question. Do you agree that Carpenter is the most important Fourth Amendment case in years, as John was saying?
Oh, absolutely. I mean, it has huge implications for both the government and for private citizens. I mean, I think the government has gotten very used to using the cell phone information, and the idea that it can't, I think, will be a staggering one for its investigatory purposes. But I think also, the concern is, is the court going to really go back on some of these old cases that were, issued before we had sort of technology that really gives the court pause about incursions on privacy. And so we may be seeing actually not only, how this case is going to come out, but what they're going to do with, decades-old doctrine. So.
Yeah, I fully agree with all that. And look, I think there's 2 interesting questions. One, I'll bounce back to John. Did they take this case to develop some kind of cell phone specific Fourth Amendment theory? And how do you, if they are concerned about cell phones and rising technology, how do you distinguish these other kinds of, how do you make it really a Fourth Amendment that's applicable only in this new context? It seems to me tougher to write than they might initially think.
No, I think you're right. I think it is kind of hard, tough to write. And I mean, especially because it has implications for so much other stuff, like your URLs, because, a phone number, admittedly, it will tell you who you called. But a URL will, allow people, if they can get your browsing history, they will know exactly what you were looking at. They'll see that you were, filling out the order form for, blow-up dolls or something. Total hypothetical. But, in that it has so much, really profound privacy implications. And I think that, that's one thing is there's so many ways this could go, and we have very little information to guess how it will go based on what they've done, because this is kind of all terra incognita. There's been a little hints in Riley, the cell phone case, and there's been little hints in Jones, but there's a lot of doctrine that's out there, and as you say, none of these justices were on the court, and many of them weren't even active in law when the relevant cases were decided in 76 and 79.
Am I right in thinking there was no split, so they sort of,
yes.
they reached out for this?
Yeah, it's splitless. I think that that's more significant than a lot of people do. Like, I think, I think that shows disquiet with this idea that they took it without a split, whereas there are plenty of others who are who don't think it's as significant because everybody's just saying we're bound by these Supreme Court cases, and so they thought, we're not going to get a split, might as well take it.
All right. Todd is coming back to recognize questioners. We're going to have a traveling microphone here.
Yes, and actually I'm going, while the audience could pose your very succinct question that's actually a question, I'm going to take the co-host's prerogative to actually ask our panelists to take an extra minute each. Mike, you didn't get to talk about one of your 3 cases, so you can use your 1 minute that way, or, as I'm asking John and Ginger, are there any currently pending petitions or cases or petitions on the horizon that you think are likely candidates for the court this term? Do we want to, Mike, you want to begin?
Yeah, the case I was going to discuss is what I think people are calling the arbitration trio cases, which basically asks the question, in an employment context, can you require an employee to sign an agreement that all employment disputes will be subjected to arbitration rather than joining a class action or suing you in court? You may remember that a couple of terms ago, I guess ATT versus Concepcion had a very similar issue with respect to consumer arbitration agreements. You buy a product and you agree to litigate or resolve any disputes through arbitration, and that was upheld 5-4. I think a similar thing will occur in these cases. The FAA says you need to interpret arbitration agreements seriously and in terms of what they say. The only exception to that in terms of federal law is if there's a federal law that sends a clear message that arbitration is disfavored. Interestingly, the federal law at issue here is the FLSA, which deals with overtime and the like, and no one even argues that the case that they would be litigating about prevents arbitration for resolving that. They go to a different statute, the NLRA, and they say, well, look, the NLRA really likes collective bargaining, so that must mean they like collective lawsuits in federal court, and therefore this would override the FAA. It seems to me there's two problems with that, which I think a majority of the court will perceive is, one is there's an obvious difference between collective bargaining and collective action in courts. And number two is a lot of these cases have already said, look, simply because you authorize something like collective bargaining and authorize suits outside of the arbitration context does not mean that arbitration is forbidden. You need to affirmatively override the arbitration option. And I think it's a pretty serious stretch to suggest that the NLRA did that. But that's, I think, being argued Monday, right? And we'll find out soon enough.
John and Ginger, do you have cases to watch?
Nothing too specific. I will say, though, that with all the rumors about Justice Kennedy maybe retiring after this term, I think one thing to watch for will be whether there are any petitions that are sort of rushed up, and that would happen this fall. It would have to happen this fall for something to be granted in time to be heard this term. But are there cases that people feel like it would be better to have decided while he's on the court? And there are some things that he's actually invited to some extent. A couple years ago, he essentially said that he was interested in long-term solitary confinement in prisons and whether that's a violation of the Eighth Amendment or some other right. I don't know if there's anything percolating, but that's something that seems to be an interest of his, and so it could be that people are trying to bring that up. I know that there's a petition pending that challenges the federal death penalty, or challenges the death penalty generally, I think. I'm not sure exactly what stage that's at, but that might be another issue where people feel like better to have Kennedy on the court than not. So I think one thing to watch for this fall is to see whether some of these big ticket items are brought up in kind of a hasty way.
I don't have anything that I specifically want to mention for fear of jinxing myself, but the one thing I think there may be interest in is revisiting qualified immunity. One of the opinions that I, not that well watched, but very significant, was Justice Thomas wrote a separate opinion in a qualified immunity case last term, suggesting that the court may have gotten off track with that and they need to revisit it. They've wandered away from its roots, citing a forthcoming article by Will Bode, which has already been more read than most published articles. And there's petitions pending now. It's being argued in kind of current qualified immunity cases that it will probably be resolved on other grounds. But there are petitions now that are calling for the court to revisit qualified immunity, and maybe that will come about.
Okay, thank you. And now I will recognize our audience members. Frank here has the mic. Please wait for the mic so that we can all hear you, and the recording will capture your melodious voice. Please state your name, any affiliation, and that short question rather than a personal statement. As is our practice with our media co-host, we give preference to the professional press. So if there are any of you, raise your hand even higher, and I'll try to recognize you. But we'll begin right here with this gentleman.
Thanks. It's Mike McGough from the LA Times. This is a question about Masterpiece, somewhat spun off from what Mike Carvin was saying. Does the Supreme Court have the option of second-guessing the Colorado courts and the Colorado Civil Rights Commission's determination that refusing to bake the cake was an act of sexual orientation discrimination? Or is that simply a state law question that has already been decided they have to accept?
I think it's at worst a mixed question of law and fact, so I think they'll feel free to disagree with Colorado if they disagreed with them. They could even write around it and say, whatever label you attach to the kind of discrimination he was doing, we're drawing a distinction between events that celebrate a certain lifestyle and discriminating against the people themselves, the Klan versus white people distinction I was talking about before. So you could always read into it. Whatever label affixed to it by the Colorado State Court is not binding on us as a constitutional matter.
And one thing to keep in mind with that case, too, is there's this whole kind of strange thread of law saying that in First Amendment cases that the court gets to revisit factual determinations, too, that is brought up both in Boy Scouts of America versus Dale and in the Hurley case itself. So they have more leeway in that case than they might.
Yeah, I mean, there's actually Bose versus, that says the appellate courts need to do their own independent fact-finding if First Amendment issues are at stake. So, yeah, I don't think they'll feel bound.
Ginger, anything?
I agree with him.
Okay. And thank you, Mike. Sorry I didn't, I'm glad I recognized, member of the press. Sorry I didn't recognize you by name, though. Okay, I think we'll go with Paul.
Yes, hi, Paul Kamenar. Thank you very much. Question is to Ginger. Like John, I didn't spend much time on the travel ban case because I would get nothing done either. But as I understand it, the travel ban was a temporary ban to ban immigrants while the administration does some efficacy of their vetting procedure for 90 or 120 days. So the first question is, well, isn't that now moot, number one? And number two, did the lower court orders not only stay the ban of the immigration, but also stay the ban of the of vetting procedures? It seems to me, who would have standing to challenge that if they're still coming into the country? How are they injured by the administration doing an internal review of the efficacy of their vetting procedures?
So to take the first one first, the review periods have ended for visas, for immigrant and non-immigrant visas. That was, I think, a week or two ago, and that's why we have a new order that now reflects the results of that review. The review for refugees is going to end in a few weeks, I think, and so presumably at that point we get a new order on refugees as well, and that part of the travel ban becomes moot as well. So the orders. Initially, I think one of the lower courts had stayed the vetting process as well, but that was reversed. And so that's why the reviews were able to take place during the summer, while the ban was being, enforced in part and enjoined in part. And so that's why the reviews have happened. In terms of what standing one would have, to challenge increased vetting, the standing arguments have to be based on, people who are in the U.S. as opposed to, the people who are outside the U.S. They typically don't have standing to challenge immigration policies because they have no right to come into the U.S., no constitutional rights outside the country. And so, I don't know. It could be things about delay, in being reunited with family members. I think the Establishment Clause standing theories have been pretty broad. The idea has been that if this is a violation of the Establishment Clause because it discriminates on the basis of religion, then it is essentially stigmatizing everybody of that religion in the country. And so, there have been pretty broad theories, whether they be upheld by the Supreme Court is another question.
Ginger, I don't think this case is going to go away. I think it'll be postponed, but I'd bet a lot of money it's going to go back.
It's going to go back.
Hawaiian Court's going to do what it's going to do, Ninth Circuit. So whether it gets back this term is probably doubtful, but I don't think they conduct this for all time. Do you? I mean, it's just really more of a...
Probably not. It seems like it may come up as an easier case
Well,
because now there's a record.
Yeah.
Right. It doesn't look quite the same way it did before.
Thank you. We start about 7 after. We have about 5 minutes left. We'll go this gentleman in the back first, and then in the second row, Frank.
John Vecchione, Cause of Action Institute. This is on the wedding cake case again. Why, if it's been held over so many times, what changes that we assume the conservative judges would vote to take it up rather than wait till maybe there's new court personnel in the next term?
I think that it probably was Justice Gorsuch shook the votes loose with a separate opinion. I think he was probably drafting a dissent from denial of cert, and I think that's probably what shook loose the votes. But I don't think anybody really knows, and no one living in this room will know either, because I'm sure the papers will all be held until we're all worm food.
Hi, my name's Al Gombis. I'm just here as an interested citizen. There's been a lot of media attention this week about Justice Gorsuch's address to the Federalist Society at the Trump's Hotel here in town. And I'm just wondering, this is a couple of different takes on it. One is that somehow this is benefiting Donald Trump, and the other side of it is that the Federalist Society played a large role in his getting appointed to the court. And I'm just wondering, in your views, is this much ado about nothing, or is there something to this?
Yeah, I think it's much ado about absolutely nothing. I think you're actually conflating two things. He's coming to speak to the Federalist Society in November at Union Station, and he's been criticized for that. But Justice Scalia's there, Justice Thomas has been there, Justice Alito's been there, Justice Ginsburg, Justice Breyer, I'm pretty sure Justice Sotomayor have all gone to the left-wing alternative or, liberal-leaning version of the Federalist Society. I don't know why anybody would think that that's bringing into question your impartiality. The Trump Hotel, I just think it was more of a gotcha kind of media fact. As I understand it, the people who organized the event had booked the Trump Hotel as their venue and done it prior to Trump being elected president. So it'd be a little odd for me if Gorsuch will say, I'll speak to this group, but not at the Trump Hotel. I think that these things tend to get a bit exaggerated, and I doubt that it would have happened if Justice, let's assume Merrick Garland was on the court and had gone to an ACA meeting. I doubt seriously you'd get the same level of media interest that Justice Gorsuch is getting.
My name is Charles Carell, no affiliation, but I was wondering on the oil states case, to what extent would a decision favoring Article III courts have deeper ramifications for the use of administrative courts by their executive agencies?
There certainly could be ramifications. It sort of depends on how broadly the court issues its decision. There's a lot of existing doctrine right now that says, public rights types cases can go to administrative courts. Private rights, which are common law rights between private parties, generally have to stay in the Article III courts. So the court could write a pretty narrow decision that says, because of very specific historical, characteristics of patent rights, we think they fall closer to the private right side of the spectrum. So then that might not have too many broader ramifications for other types of cases. Or it could write something more broadly that, that more strictly constrains Congress's discretion to put things into administrative courts. So I think it just depends.
I think we have time for one more brief question. Okay, and we have one questioner here by the videographer. As long as we don't knock over the, okay, we didn't knock over the camera. Very good.
Stuart Reuter. Recently, I guess just the other day, the D.C. Appeals Court did not decide on a Second Amendment case, letting its own 3-section stand. Does D.C., who have been against Second Amendment rights forever, government, dare to appeal that to the Supreme Court?
I don't really know, but I was surprised that they didn't take it en banc in the D.C. Circuit because it was a concealed carry case. I think, if I'm not wrong, the panel had a dissenting opinion, so it was pretty odd that they didn't take that case up. Now, I think the normal response has been to go ahead and go to the Supreme Court. They've pretty consistently turned down all these Second Amendment cases in the wake of Heller. But this one seems like the kind of case that they might finally say, listen, there's enough confusion out there. I think there's arguably a split, if not on this precise issue, on very closely related issues, so all the normal indicia for taking the case would apply. I think if D.C. goes up, unlike the cases last year that I didn't think they would take, I think there's a pretty decent chance the court will do what it's been reluctant to do in the wake of Heller, is to wade back into this controversy and give people more precise guidance on what's constitutional and what's not.
Your answer suggests my follow-up. The cynic in me says the D.C. Circuit is both full of very bright and politically active judges, and generally when a case goes en banc, there are a lot more opinions and it's a little more attractive for the court. So do you think that a majority may not have wanted to bring any more attention to this case?
Yeah, I haven't followed this closely enough to even reasonably speculate about. The counter argument to what you just said, Todd, is that, well, if they had upheld this law, I think it would have eliminated the split in the circuits, and for that reason would have made it less interesting for the Supreme Court. Now, again, I haven't followed this that closely. I don't know if you guys have, but I think there's a pretty clear split on these issues.
Yeah, it has been kind of shocking, though, the extent to which the court has passed up some of these cases. I mean, when I was in the government, I'd see a lot of these coming. They'd often be against the United States because of the United States gun laws. And there were some that seemed, objectively to be quite good candidates and some confusion in the circuits. But the court just never took them and declined to clarify the standards. So it seemed like there was a real lack of interest, at least for the past couple years, in getting back into this. Now, whether Justice Gorsuch changes this, could be. So.
Very good. And yes, thank you, Mike. I think you've corrected my reasoning. And with that, I think we will conclude our program, but I want to do that with you all joining me in applauding and thanking our panelists.